challenges and transformations of European administrative law. The panelist is very well known here in this faculty. It is true that he's not a professor at the faculty, but he's the research director of the Center for European Studies, and he is also the chairman of this chair about European and global administrative law, and he has just won a research project on the subject. So it is honestly an honor to have you with us, to Professor Arroyo. Thank you for coming. Thank you for organizing this seminar, and you have the floor.
Thank you, Isaac. It's a great pleasure to be here. I will present a paper that I am currently drafting, and the topic that I am dealing with is European administrative law challenges and transformations. I will structure my presentation in 3 parts. I will first talk about the concept and the main characteristics of European administrative law. I will then take a look at the main problems or the main shortcomings that have been diagnosed by the academic scholarship. What are the problems that we are facing now in this area of law? And finally, I will say some brief words about what is actually a normative claim, which is that I think that the systematization or the improvement of systematization of European administrative law may help to resolve, if not all, at least some of the problems that I will identify. Let me begin with the concept of EAL, of European administrative law. What I'm talking about when I speak about European administrative law. Well, on the one hand, European administrative law is part of EU law. So what I am meaning is rules, principles, doctrines that formally belong to the system of the European Union. So EAL is a part of European Union law. Nevertheless, we cannot overlook something that Emilie has told us this morning, which is that European administrative law, like EU law more broadly, is a legal system which is open to other legal orders. And in particular, it is open to the national administrative legal system. So there are legal reasons that are incorporated, that gain some kind of effectiveness within EAL, which nevertheless have its origin in the law of the member states. And pretty much the same happens with international law. European Union law receives some elements from international/global administrative law as well. On the other hand, the object of European administrative law is the European administration. And here we have a very huge problem when we try to answer the question, what is European administration? A note for Spanish students, in EU law, we don't use a subjective criterion in order to define the scope and limits of European administration, unlike what we do in Spain. In Spain, administrative law is the law of a peculiar subject, of a peculiar actor. This is something that we cannot realistically do in European administrative law, because the European Union institutional system does not reflect a traditional separation of powers structure, and therefore it is very difficult to really know where is the administration in a subjective perspective. So unlike what we do in Spain, we have to define the concept of European administration and therefore the limits and scope of European administrative law according to functional criteria. Administration is a function, is a characteristic type of action of public bodies. And essentially it relates to the executive tasks that are comprised in the implementation of European Union policies, no matter the area: fisheries, agricultural policy, pharma, internal market, competition. In all those EU policies, we can find some typically administrative or executive tasks. Well, European administrative law is the part of the law of the European Union which deals with the implementation of these functions. Nevertheless, a functional criterion only led us to engage in a kind of exploratory or tentative approach. It doesn't allow us to build a categorical definition so that we can be completely certain if we are within or outside the boundaries of this area of law. More interest for our current purposes have, nonetheless, the question of how does it look like? How does EAL look like? What are the its main characteristics, its most peculiar features? And in this respect, the point that I want to stress is that EAL is very different from the administrative laws of the member states. And in particular, that these peculiarities, these distinctive features, are sometimes connected with some of the shortcomings that I am going to tackle later. So in these peculiarities we can find the origins of some of the problems I will refer to later. The first peculiarity is that EAL applies to multi-level jurisdictions. That means that European administration develops on the national level, because national administrations are entrusted with the ordinary administrative implementation of EU law, but it also develops on a supranational level when it comes to the direct enforcement of EU policies. For example, in the field of antitrust, it is very common that the implementation belongs to the European Commission. And it also develops, thirdly, within global networks of administrative cooperation. It is more and more common that European institutions and agencies engage in cooperation relations with other international administrations or even with the public administrations of third states. So we have these different jurisdictions on which European administration is performed. A second characteristic is subjective pluralism. That means that European administration is entrusted to many different types of actors. Within the European Union system, we have first some institutions that take administrative action, for example, the Commission, of course, but also the Council or the European Central Bank. These are institutions entrusted with administrative functions. We have dozens, literally dozens of European Union agencies dealing with the most different and varied areas of law, from pharmaceutical products to energy regulation, to competition, you name it. Any area of law, of public law in the European Union has more or less formalized administrative structure. And we also have, again, literally hundreds of committees, of specialized committees, most of them composed of experts designated by the national governments. And there are, for example, what could I say, a committee specialized in the technical issues of interconnection of electricity networks. And there is another expert committee dealing with the bioethical issues posed by the genetic modification of organisms. So there are, as I've said, hundreds of committees, both within and outside the scope of application of the comitology regulation. And next to the European Union actors, we can also find many different administrative authorities of the member states that implement administrative action enforcing EU law. and which do not only act within the territories of their respective jurisdiction. We don't only have Spanish administration applying EAL in Spain or French administration applying European administrative law within the French territory. On the contrary, those administrations, despite being national, can also take action on the territory of other member states through one figure which is called transnational administrative acts. These kind of administrative acts are those decided by, for example, an administrative authority of Spain, which nevertheless deploy some kind of legal effects all over the territory of the European Union. So we have an example of an administrative authority taking decisions which, despite its national nature, produce legal consequences, legal effects in the territory of other member states. And national authorities also take action inside European administrative bodies. Before I have said that the technical and expert committees are composed of national experts, and in fact those members are nominated, are designated by national governments. So we have there another example of national administrative law decisions that have an effect within the organization of a supranational body or committee. Okay? And this brings us to another peculiar feature of European administrative law, which is that we can observe here a strong administrative integration in administrative networks. The concept of network is crucial in European administrative law. What are networks? Networks are specific combinations of organization and procedural law, which are created for the cooperative exercise of administrative competences by both supranational and national authorities. Sometimes these networks have a high degree of integration and are, for example, agencies. So we have created in those cases a new body, a new public body with legal personality, with budgetary competences, with the prerogatives to take formal decisions. For example, the European Medicaments Agency or the European Banking Agency. These are examples of highly formalized administrative networks, but in other cases we don't have a special body. What we find are more or less formalized cooperative structures, so that the national administrations cooperate among them through a specific procedural arrangement. So instead of using organizational law, what we call in Spanish derecho de la organización administrativa, we use procedural law. And we can get a high degree of integration using procedure as well. For example, composite procedures or duties to inform or rights to get access to administrative information in the hands of other national agencies. Through procedure, we can also get a high degree of integration. So European networks are different combinations of organizational and procedural law for the cooperative or even for the joint exercise of administrative competences. Another peculiarity of European administrative law is that historically it has not developed according to a more or less defined concept. It has not followed, let's say, close bureaucratic design. It has developed rather in an experimental bottom-up manner. So it is kind of spontaneous. It has not been developed, for example, the new agency created in any area of administrative law has not been usually created according to general criteria, but in view, above all, of the particular needs of the sector at stake. What is what we really need in the field of energy regulation? What is what we really need in the field of agricultural policy? And next to these sectoral needs, what have been taken into consideration mainly are the preferences of the stakeholders, of the particular stakeholders. For example, what is the view of the Commission officials that have been active in this area of law until now? What are their views? So instead of making a bureaucratic design, let's say top-down, from the big principles to the reality, they have or we have operated the other way around. And this gives rise to another characteristic which is probably in the origin of some of the problems that we are facing, which is what we can call sectoral pluralism, meaning that there is little coordination between different policy areas. Sector-based administrative law is very particular, it's very plural, it's very diverse. And this is the consequence of two reasons. For one, the rules and principles of crosswise nature, rules and principles that apply regardless of the sector of administrative action we are facing, are rather scarce. We have a bunch of principles of law, for example, the principle of good administration, about which we have heard something this morning. We have also a bunch of provisions of secondary law, for example, the financial regulation, that regulate how the European Union grants awards or grants contracts or grants aids. But leaving aside these rules and principles, if we want to know which is the law that applies to a specific sector of law, we have to look at sectoral legislation. So sectoral pluralism is very prominent, I'd say, in EAL. And the final characteristic that you have in the slide is openness. EAL is to global administrative law as well as to the administrative laws of the member states. As regards the former, as I have said, it is very common that European Union agencies engage in external action. For example, Europol, when interchange security information with other security agencies all over the world. Or the European Banking Union, when interchange best practice information with other banking supervisors and regulators. So we don't have external action only by means of or through the European Council or the High Representative or through the European Commission. Each European Union agency is potentially an actor of international relations. And another example of openness towards national law can be found in composite procedures, which are very prominent in European administrative law. Composite procedures are administrative procedures which end with a decision taken, let's say, by an European agency or by the European Commission, in which nonetheless national administrations partake. So we have like procedural steps that take place at a national level, which nevertheless will end with a decision taken by the European Commission or by a European Union agency. Or the other way around, a preparatory decision taken by the European Commission, which has to be implemented through acts adopted by a national public administration. These are vertical, ascendant and descendant, or with other words, top-down and bottom-up procedures. And this is very typical of European administrative law. Well, where are the main problems, the main shortcomings of European administrative law according to the general opinion? I have brought here two examples of what we can call mainstream or orthodox views on the matter. The first opinion is Eduardo Kittis. He's an Italian author who, in a recent paper published in the European Law Journal, basically claimed that European administrative law was failing in 3 crucial tasks, which in principle should be performed by this sector of law. The first of this failure is the following. The balance between the need to promote convergence of administrative laws in Europe on the one hand, and the need to preserve some kind of pluralism, some kind of diversity, has not been struck, in his view, according to a carefully assessed criterion, but rather in a, let's say, arbitrary manner, in a half-hearted, how do you call it? Can you? Half-hearted. So, casualmente, no? Yeah. So the point of equilibrium between integration on the one hand and keeping diversity on the other hand has been struck without thinking very much about it. Why? Because it has been struck on a sector-based perspective, without taking into consideration global principles or general ideas about how this dialectical relationship should be resolved. A second problem here is the imbalance between effectiveness of European administrative action on the one hand and the need for legal rationalization of this European administrative action. And this can be demonstrated, according to Kitty's view, in 2 examples. On the one hand, in some areas of administrative law, European agencies enjoy an excessive amount of discretion. So discretion is running amok, so to say. No? And a second example is that we can observe, generally speaking, a lack of political and judicial accountability of European administrative networks, a topic that I will tackle later. So accountability is very weak when we think in how administrative decisions are controlled once they have been taken. And the third and final criticism made by Eduardo Kitty is that there is some kind of imbalance as well between flexibility and stabilization of administrative action. And in particular, the problem that we are facing is that in some areas of EU law itself is refusing to clearly orientate and steer the production and implementation of European administrative law. It is not only that in some areas we can find too much discretion, but also that in other areas hard law is retreating in favor of soft law in a degree which is considered to be excessive. For example, in the field of state aid law, it is simply not helpful to take a look at the hard law because the devil is in the details and the details are in soft law documents. No? So apparently hard law has refused to direct, to steer, to orientate, to rationalize European administrative law. And the same happens, for example, in areas like energy regulation, where secondary legislation has granted vast amounts of power to European networks without clearly defining the objectives, the goals that have to be pursued through the exercise of these prerogatives. Sometimes there are simply no goals normatively defined, or other times there are, this is the opposite situation, there are too many goals, too many contradictory goals, and therefore there is no clear orientation of how discretion has to be exercised. Well, if we take a look to the second piece of scholarship that I wanted to talk about, this is the very famous book by Hoffman, Rove, and Turk, Administrative Law and Policy of the European Union, 2011, so it is already a rather venerable handbook of European administrative law. In their view, European administrative law is facing three main problems. The first of them being excessive fragmentation. That means that European administrative law lacks of a general part, of a general theory. And we should, in their view, tackle this problem with a double strategy. On the one hand, we need more horizontal, crosswise legal provisions in European administrative law. They are very much in favor of the codification of administrative procedure in Europe. If not, when it comes to the regulation of national administrations implementing EU law, yes, when it comes to direct administration, when it comes to the administrative procedures that take place before European agencies and institutions take decisions. And on the other hand, they also think, and I agree with them, that we need to build a more general theory of European administrative law. And this is what I'm going to develop in the third and last part of my presentation. They also claim that we are suffering what they call a normative or conceptual gap in European administrative law. They say that there is an excessive distance between how administrative functions are actually performed and the law that is supposed to order or to steer the performance of those functions. So there is an excessive distance, an excessive gap between theory and praxis of administrative action. If you want to know how administrative action is, probably it's not a good idea to take a look first to the law, because the law doesn't provide us with a lot of clues in this respect. And finally, actually Adam is an expert in this kind of topics, accountability gap. We are suffering an accountability gap here because administration is in Europe, as I have said, integrated in European networks. So administration is performed in a cooperative and joint manner, for example, through committees integrated by both European and national experts, while the most important accountability mechanisms are not integrated and develop in a completely separated manner. And this is true for both political and judicial accountability. With respect to political accountability, the problem is not only that the operation of these administrative networks is very opaque, is not transparent at all. The problem is that political representation, which is the process in which we can demand accountability, in which we can claim for political responsibility vis-a-vis the administrative decisions and political decisions that we dislike, do not develop between the supranational and the national level. They develop strictly in these two levels of government. So we have the European elections, and we can claim for political responsibility in this political process, and we have the national elections where political accountability can also operate. But the problem is that decisions related to how energy is regulated are not taken, strictly speaking, at a European level or at a national level, leaving aside the big decisions which are taken in directives. I mean, the regulatory decisions are taken in a European agency, the European Agency for the Cooperation of Energy Regulators. And this agency is something in between the European level, the supranational level, and the national sphere. And therefore, there is some kind of short circuit between who is deciding and in which level decisions are taken, and how can we citizens how can we citizens claim or demand for political responsibility if we dislike the decisions that have been taken by these agencies? No? And something similar happens in terms of judicial control. First of all, annulment actions are completely separated. That means that European courts are not entitled to annul, to quash administrative decisions taken by national governments or administrations, at least until 1 month ago, when we had this very important ruling of the Court of Justice, which annulled an administrative act taken by a national administration for the very first time, but this is, strictly speaking, an exception. And the same happens the other way around. National courts cannot annul decisions taken by European networks, by European agencies, or by the Commission, of course. No? And at the same time, preliminary references can only operate in a top-down direction. But in many cases, the Court of Justice has to interpret national law and has to verify whether, for example, these national decisions that are incorporated into a composite procedure, ending with a decision taken by a European authority, are lawful or are not lawful. And in these kind of situations, the Court of Justice of the European Union cannot make a reference for a preliminary ruling in a top-down direction. So this is another problem that we are facing in terms of matching how decisions are taken on the one hand and how accountability works on the other hand. Well, let me just end by saying something about systematization. I will not get into the details of these, but what I was trying to explain in this paper I am drafting is that systematization of European administrative law may contribute to improve it with respect to some of the previously mentioned problems. For example, the three imbalances that have been denounced by Eduardo Kitty, these three problems, and particularly the excessive fragmentation pointed at by Hoffman and Turk. Well, these problems can be partially, at least, resolved if we engage in what we in the continental Europe traditionally call systematization of administrative law. And what I mean with that, we come apart from an empirically verifiable truth, which is that legal orders are not perfect systems. They are not systematic. They are not coherent. They are not unified legal orders. They lack fullness because there are lacunae, there are contradictions. So law is in fact not systematic. But at the same time, the characteristics of a system, of a legal system, coherence, fullness, unity, operate as a regulative ideal. That means that they work as an ideal type to which reality can be more or less close. So legal orders can be more or less systematic. Bye-bye, have a good trip. Well, systematization of European administrative law is an academic project which essentially aims at doing two things. On the one hand, it aims at identifying the elements that approximate a legal order to this ideal. I mean, what European administrative law has of a legal system? What make EAL coherent or full or unified? What approximates EAL or Spanish administrative law to the regulative ideal of a legal system? And secondly, it is also aimed at making proposals in order to bring the law that we actually have, more closer to the ideal of a system. So we are supposed also to make proposals in order to increase the degree of coherence or increase the degree of fullness or increase the degree of unity of European administrative law. And this is something that we really lack in European administrative law. It is not only an opinion held by some obscure German legal scholar. It is something that we are pretty much in agreement that we lack of. Well, I think that we can finish here. Maybe since our English friends are gone, we can change to Spanish, so that if any of you have alguna pregunta, pues la podéis presentar, la podéis plantear sin problemas. Así que, bueno, eso es todo.
Thank you very much, Luis. Si tenéis alguna pregunta, podéis plantearla en castellano. No sé si como nos están grabando a seguir en inglés por hacerlo completo. I'd like to hear your opinion on this ECJ's judgment, annulling a national act. Just your opinion on that.
The case is very recent. The problem, well, it was a very complicated issue because it came from Latvian law, Latvian legislation relating the nomination of officials of the National Central Bank of Latvia. And this was one part of the problem. The other part of the problem was criminal procedural law, criminal proceedings. And the problem was essentially that there was this national decision ending the right of the person who had been nominated as president of the National Central Bank to enjoying this position, because he was being prosecuted, or at least investigated by the courts. And this national decision ordering the expiration of the office was in the origin of the case. The problem is that national central banks of member states of the Euro system do also belong to a European institution, which is the European system of central banks. And therefore, they enjoy a double hat, a double position. On the one hand, they are officials of the national administration, but at the same time, on the other hand, they are also members of a European institution. And therefore, this national decision had an effect in the supranational institutional system. This is the reason why the European Court of Justice did dare to annul the act or the decision taken by the national authorities. Interestingly enough, the legal services of the European Central Bank suggested that the Court of Justice might limit the judgment to declare that the member state had infringed European Union law, thus giving a merely declaratory ruling. But the European Court of Justice declined this suggestion and went directly to annul the national law decision, which is, as I have said, something that had never happened, because in theory of general international law on the one hand, and in theory of European Union law on the other hand, EU law and national laws are legal systems that are communicated in terms of effectiveness, but not in terms of validity. That means that the validity of national rules cannot be assessed under EU law and the other way around. The validity of supranational decisions cannot be assessed, despite the opinion of the German Constitutional Court, under the perspective of the national constitution. What the national constitutional courts can do is to declare that EU law is not applicable in the territory of the member state, but not declare that the supranational decision is null and void. This is something that can only be declared by the Court of Justice, by the European courts. So this is the very first time that this strict separation has been exceptioned. And well, something that this will remain within the boundaries, within the limits of banking law, which is a very strange animal in European Union law. But the truth of the matter is that we have plenty of European agencies in which those officials do also have this double hat position. So, well, let's see if the earthquake that this ruling has provoked is limited to the area of banking law, or if it is going to expand to other areas of European administrative law.
Okay, thank you very much. Any other question or comment? Please.
Do you think that a reform of the actions before the European Court of Justice is also needed in this process of systematization of the European administrative law? Because any administrative law system has to have the possibility for citizens to challenge the administration decisions before a court. And nowadays it's really difficult for European citizens to bring a legal action against, for example, a commission decision in the ECA.
Well, I don't know if this task belongs to the research agenda that I have called systematization, but in any case, I think that we have to somehow open the door of the court, and in particular the access to annulment actions to individuals and NGOs. So I think that we need to make some room for a more active and more decentralized access to justice. So Article 263 of the treaty probably should be either reformed or interpreted in a more generous way by the Court of Justice. This is my view. But this is a view related to a particular area of European Union law and not specifically to this systematization project.
Okay, I think we all need a break. We are having a break of 15 minutes. We will be back at 6 o'clock in order to finish before 7 o'clock. Okay, so you will be free after that hour. Thank you.